Hi, I'm Joe Denneler. I'm an attorney. I am the program attorney for the RESASURE insurance program operated by Villanova Insurance Partners. Work in conjunction with Victor D'Angelo and Judy Phobes relative to that program, the insurance coverage, and more importantly, the risk management components of that program. Today we're going to talk a little bit about your service agreements. We're going to discuss some concepts about what needs to be in them, what shouldn't be in them, how we should lay them out, and we'll talk about various topics that come up with service contracts, include defensive clauses like limit of liability, and we'll talk generally about the types of things you need to mention in your contract. After we do the video session, there'll be a Q&A session where we can follow up on any specific questions you had about the program or any of the materials we presented. A good service agreement should set out the understanding between you and your clients. It should let your clients know what you're going to do and maybe more importantly what you're not going to do. And it should have provisions in it that protect you from litigation and affords you defenses from liability. One of the most important tenets of your inspection agreement is that it has to be easy to read. It has to be something that somebody can easily look at and understand, and it can't be something somebody has to squint at the type, or it can't be something that's jumbled up, taking up an entire page with no margins. It needs to be readable to the average person. It can't be unconscionable. Unconscionable is a legal term that basically means unfair, too one-sided, or too egregious. It has to shock the conscience of somebody reading it in terms of whether or not they think you should be required to adhere to it. So, for example, a judge would look at your service agreement if you were in a litigation matter, and the judge would have to decide whether or not your agreement was unconscionable. Was it too one-sided? Did it favor you more than your client? Because with any of your service contracts, it's a basic boilerplate agreement that you're going to use over and over again. In the law, that's called a contract of adhesion, because your client doesn't have a lot of wiggle room to negotiate any of the terms. With a contract of adhesion, a judge or an arbitrator is going to look carefully at the agreement because it's clear that the client did not have any bargaining power with regard to that agreement. When you have an agreement between two businesses who are equally sophisticated in terms of their knowledge of the business, the court's going to look at that more favorably in terms of letting the parties agree to what they want to agree to. But with the average consumer, a court or an arbitrator is going to look much more closely at that agreement to determine whether or not it's fair and should be enforced. There may be provisions of the agreement that a court or an arbitrator won't enforce for one reason or another. That doesn't necessarily mean the whole contract gets thrown out. What generally happens is a judge or an arbitrator will carve out some of the provisions in the contract that are deemed unfair, but keep the other ones. In some cases, if the language is unclear, a judge or an arbitrator is going to try to interpret what the parties must have meant when they agreed to that contract. And it has to be informative for the client in terms of, here's the things that you need to look at carefully and understand. We need to set some provisions apart from the other provisions of the contract. Now, the easiest way to do that is using italics or underlining or bold type, but some way so it catches the reader's attention so they know that this is important. In my 20 years of experience dealing with service contracts, I've had many occasions where a judge refuses to enforce the contract because critical language like a limitation of liability or a limitations period within which somebody can bring a claim is buried deep within many other provisions so that the reader doesn't really know what's more important than something else. And so it's important that we set the provisions off, use numbering, use titles for the paragraphs of the agreement, but some way so the client knows what each specific provision is and which ones are critically important and might take away some of their rights that they would normally have outside of the contract. We're going to talk about some of those clauses that limit the consumer's rights to bring an action or to collect damages from you as we go on with the program. Timing of the service agreements and particularly making sure that your client has adequate time to read it are important. It's very important that your client has the agreement, I would say, at least a couple of days before the services are to start. I know with staging services, for example, there is some lead time because there's some planning involved. With home inspections, for example, another real estate profession, sometimes they get called the day before they have to go do the job. With stagers, in my experience, you've had a little bit more time to get your documents out to your client. So it's important that you get your service contract out to them as soon as you book the job. Let them review it, make sure they have time to review it before they have to pay for the services or the services start. We want to make sure they have the opportunity to review it with their lawyer if they have one. What this means in the future, if you do have a claim, is that your client then can't say, well, you know, I needed to have the services done right away. They showed up at the job, threw a couple pieces of paper in front of me and made me sign it, and I didn't really understand what I was agreeing to or what I was giving up. So if they have it for a period of time where they can give it due consideration, it's less likely that they can successfully claim that they didn't understand what they were agreeing to, or if they were somehow rushed or forced under duress to sign your agreement. And always have the agreement signed before you start any work for that client. That's not to say you have to have the agreement signed before you sketch out the proposal, but it's important that you have the agreement signed before you start the work. Because if you have it signed later on, I've had occasion where some judges have said, well, I'm not going to enforce that agreement against that consumer because the services had already started and they didn't realize they had an opportunity to consider that. So always get the contract signed before you start any work. It's also important to make sure that you know who is signing your agreement and who should sign your agreement. If you're doing services for an owner of residential or commercial real estate, you always want to make sure that that person is signing your agreement. I understand that in many situations you might be contacted by a broker or agent or somebody else in terms of the real estate transaction. However, it's important that the person who owns the property where you're going to stage things has signed an agreement, because a lot of the provisions in a good service agreement for stagers are things that relate to how the owner of the property relates with your stuff and how you relate to their property. And so we want to make sure that you have a signed agreement by that person. If it's a situation where a third party is going to make payment on behalf of the end user of the services, then you also want to make sure you have something signed from them where they're agreeing to the terms of payment, the pricing, and the scope of the services that you're going to do. Now, we developed a stock agreement for RESASURE insureds that we freely give if you're enrolled in the program. And we're going to talk about some of the ways that you can improve your agreement if you're not part of the program. But these provisions are all in our stock agreement that we provide. With any piece of writing, you want to make sure you're writing for your target audience. And the key here is that your target audience must be able to understand what's written and be able to consciously agree to it. Unconscionability, the term we talked about a few minutes earlier, is related to the writing of the agreement for the target audience, in that we have to make sure that your target audience can understand. We're not using a bunch of legal jargon. We're not using terms that are only related to your particular profession that the consumer might not understand. We always want to write so the average consumer can understand what we've written. The average American reads at a 7th to 8th grade reading level. That means the average 13 or 14-year-old who's up on their schooling should be able to read your agreement. That's not to say that we can't use some terms that might be more advanced, provided that we explain them in the agreement so that the reader knows exactly what we're saying. Your service agreement has to have some basic items in it, whether you're doing staging, interior design, or any other service. There's some particular provisions of a contract that need to be in every agreement. First, the price of the services. You need to include in there how much you're going to charge. In some instances, you may have a day rate or a weekly rate or a monthly rate, but in some way, the reader, when they sign it, has to know what they're agreeing to in terms of the price. Your agreement should contain an adequate description of the scope of your services. We want to make sure that the reader understands exactly what you're going to do and what you're not going to do, and also to make sure they understand what things you might be bringing to the property or what people you might be bringing to the property. Your agreement definitely has to have at least the full name and address of your client and the address of the home to be staged. You also definitely need to include in there a term. The start date and end date of your services must be included in the agreement, otherwise you're leaving it up to a judge to make that determination. We need to identify exactly what things you're not going to do for the client. In some instances, the average consumer might not really understand what you actually do. And so it's important that we disclose what you do and more importantly, what you don't do. For example, anytime we're dealing with any kind of building or real estate, there may be limitations in the scope of your work caused by the layout of the building. It's something you can't help and something we try to work around, but there might be specific limitations that you need to mention in that service agreement that relate to the particular property you'll be performing your services for and at. You need to make sure that you exclude any kind of safety issues that might relate to you or your work. You shouldn't make yourself responsible to deal with safety issues involving the real estate, and more importantly, you want to make sure that the owner or the person in control of the property has made the property safe for you and for other people you may bring to the property. You want to make sure that you address any work by third parties. I'm going to talk about that in a little more detail in a few minutes, but you want to make sure that your exclusions include that you're not going to be responsible for the work of people who aren't in your employ or hired by you to work on this particular job. In real estate sale transactions, there may be multiple people working at the property all to achieve the same goal, but we want to make sure that you're not responsible for any work by any third party, even if it's somebody you recommended to your client. We need to identify conditions or deficiencies of the property that may make it impossible for you to do your work, in addition to the layout. There may be issues related to your ability to deliver items to the property because of how it's laid out or whether or not the driveway is adequate. All those things should be addressed in the specific service agreement. And one way you can do that while still using a form agreement is to include some spaces in there where you can add in information particular to that job. And that way you know you've always included the particulars of that property in the agreement in case there's some dispute later on about the scope of your work or what you agreed to do or not do. And we want to talk about the exclusions for the particular job that might involve the tastes of your client or what they definitely don't want brought to the property. It might relate to color schemes. It might relate to the style of furnishings. All those things, if they're going to be specific to that job, should be in writing somewhere, so that if there's a dispute later on, it's easy for the parties to recognize what they actually agreed to do and what they didn't agree to do. Now with service agreements, we always want to include some defensive clauses. These are the clauses that we build into the agreement primarily to protect you. And so it's critically important in your service agreement that these provisions are set apart from the rest of the agreement in some way, bold type, italics, larger type, but some way so that the client's attention is drawn to these, and more importantly, drawn to the concept that they're giving up some right in this agreement in order to have you do the services for them. One of the primary things we use in service agreements for any profession really that we can use them are liquidated damages or limitation of liability clauses. These clauses are written so as to limit the scope of the damages someone can claim in case of a breach of your agreement or in case you negligently perform your services. Generally, these take the form of an agreement that tells the client that your service price is X, and the most that the client can ever recover from you in the case of a claim of a breach of that agreement is the amount of the services or some multiple of the services or a liquidated damages amount that's separate and apart from that you believe reasonably compensates the client for the law. We want to make sure that the client understands that they're giving up their rights related to being able to sue you for an amount above and beyond what's stated in the contract. Now, in my experience, judges are often reluctant to enforce these clauses against the average consumer. And that's why it's so important that we do all the other things I talked about earlier in terms of making sure the client has the agreement in time, making sure they have adequate time to review it with an attorney and understand their rights and what they're giving up. Because at the end of the day, if someone wants to sue you for $30,000 that they claim they lost in value of the house because it's the way it was staged, and we want to cap your damages at the service fee, we need to make sure that that clause is written clearly and that the reader clearly understands what they're giving up. Because if we can do that and we can limit your exposure, it keeps your insurance rates down, it keeps your business expenses down, but more importantly, all these claims are a time drag on you and your business and your ability to run your business efficiently. Any lawsuit takes up your time in terms of giving depositions, assisting your attorney with providing discovery, appearing at court hearings and trials. All those things add up, and it takes you away from your ability to make money and to operate your business. And so we want to make sure that these things are written clearly enough that they will be enforced so we can count on them when we need to. Indemnity clauses are another defensive clause that we use in these agreements. And basically what that is it puts the onus on somebody else to indemnify you in the event of a claim. Indemnity simply means that somebody steps in your shoes and pays a debt that somebody decides you owe, for example, a court. Your insurance policy, your errors and omissions insurance policy, covers you for indemnity and defense. Indemnity and under your policy means the amount of money that a judge or a jury or an arbitrator awards to somebody who sues you, or an amount you agree to in a settlement. Defense is the money they pay to have a lawyer represent you, to hire experts to testify on your behalf, to hire investigators, to hire people to determine the value of property that may have been damaged. All those things fall into the defense category of what your insurance does for you. In this case, what you're doing is insulating you and your insurance from a claim by putting the onus on a third party to pay your defense or indemnity. The reason we do that in most situations is when we use third-party service providers as part of our work. If you have a subcontractor that you use, you want to make sure that that subcontractor is going to defend and indemnify you and your company in the event of a claim related to that subcontractor's services. So in that regard, we need to make sure that that indemnity and defense agreement is clear and set apart from other language in the agreement so that the party understands what they're signing. There needs to be a provision in there related to the timely notice of claims. The statute of limitations in most states for negligence is around 2 years. For breach of contract, it can run from anywhere from 1 year to 6 years in some states. And that's a long period of time to have somebody hanging out there who may want to bring a claim against you. And so we want to shorten that time period in your contract in states where we're permitted to do that. And what we try to do is cap that time at a year. I've never been able to get a judge to agree to anything less than a year in terms of augmenting the statute of limitations. It could certainly be possible that a judge would allow it to be 6 months or 3 months, but in most situations, a year is considered a reasonable amount of time for somebody to realize that they might have a claim and take legal action on it. And so if they don't take action within that time period specified in your contract, they can't sue you. If they do sue you beyond that time, it gives us the ability to defend you adequately by saying to a judge, well, they agreed to 1 year, it's been 15 months, and now they're bringing the claim, and we try to get the claim dismissed on that basis. And part of the reason is when we're dealing with real estate, damages to real estate, damages to physical property, time can be a factor in terms of determining the value of that loss. Something might be damaged, and a year later, that damage then accelerates and becomes worse. And so we want to make sure that we have a reasonable time period where somebody has to bring a claim, but that after that time period, you're not on the hook for a time far out into the future related to your services or any of the things you did at the property. Arbitration is another defense clause that we use in these agreements. The purpose of an arbitration clause is to keep a claim against you out of court. It's primarily done in order to facilitate an expedited hearing on the claim, in order to keep the costs down that relate to defending you, and to provide hopefully somebody who has some knowledge about your business rather than presenting your case to a jury who might not know what you do. Arbitration generally relates to a service that's provided by a third party. American Arbitration Association is one of those parties that's commonly used. But you want to make sure you identify in the arbitration clause who the service provider is going to be. You also want to make sure when you're giving out your contract that that service provider is still performing those services. I've had experiences in other professions where somebody's using a service contract for 5 or 6 years and it cites to a particular arbitration provider, and then when a claim comes in, we come to find out that that provider is no longer offering those services. If there's any deficiency in that arbitration clause, that gives the plaintiff in a case a better argument as to why that clause should not be enforced, because it's ambiguous or because they agreed to a particular provider that can no longer provide those services. And so we want to make sure that that arbitration agreement is always accurate and up to date in terms of who the service provider is going to be. And choosing the service provider is critically important as well. Some of the service providers that offer arbitration charge an inordinate amount of money, more money than what it might cost to represent you in a litigation matter, which then begs the question, why are we in arbitration at all? The other thing about arbitration that makes it a little bit tricky is that when you deal with a case in arbitration, generally there is no ability to appeal the decision of the arbitrator. So once the arbitrator makes a decision about an issue of law or an issue of fact, you're stuck with it. If you're in the court system and the judge gets it wrong on the law, we have appellate courts to go to try to get a correct determination of what the law is and how it applies to you. Now with contracts, in particular when we talk about limitation of liability clauses, indemnity clauses, notice of claim clauses, all of those things are legal issues that have to be decided by an arbitrator during an arbitration. And if the arbitrator makes a mistake on the law, you're stuck with it. There's no way to go around it. In most situations, the only way to get an appeal of an arbitration or to get the arbitration award taken off the books, so to speak, is to find that the arbitrator committed fraud. Maybe they knew one of the parties and didn't disclose it. But that's really the only way to get around an arbitration decision. So you want to make sure if you're going to go with arbitration in your agreement, that you have a good service provider, that you've vetted them, that you've asked them about what the costs are related to you, what the costs are related to somebody who might sue you. A judge is going to look at the arbitration clause to make sure it's fair, to make sure that the charges that the claimant might have to pay to initiate that service are fair and reasonable, and that there's a good chance that the consumer who's suing you is going to get a fair and adequate hearing. The court systems love arbitration. They love anything that can get cases off of their docket. They get thousands of cases filed a year, and there's definitely not enough judges in every state to handle all of them. So the court system will generally favor arbitration, provided that clause is fair and provided it's not unconscionable or too one-sided. Subcontractors create a particular set of issues in terms of risk management and liability. Generally, they're going to be a company or a person that you use on a regular basis as part of the services you provide, but they're not your employee, and we want to make sure that their services are related only to them and not to you. And the only way really to do that efficiently is to have a subcontractor agreement that you use with your subcontractors. Now this agreement can be more detailed, it can be use words that your consumer might not understand, but that your subcontractor, because it's another business and you're dealing in an arm's length transaction, your subcontractor understands those terms and concepts. And so you have a little more wiggle room in terms of what you can put in the agreement, and for it still not to be too one-sided as to be non-enforced. The subcontractor agreement should be with any third parties who perform services on your behalf, and that should also include them having a separate agreement with your client. That way your client knows exactly who's providing that ancillary service. If you're dealing with an insurance issue where, for example, you bring a third party to the transaction and the client believes that third party was negligent or breached their agreement in terms of the scope of their services, and you are sued, you need to make sure that you have a subcontract agreement with that service provider, because that service provider's insurance company is not going to defend and indemnify you unless there's a written agreement to do so. So in the agreement with your subcontractor, you want to have an indemnity and defense agreement that provides that that subcontractor is going to defend and indemnify you against any claim made related to that subcontractor's particular services. If that agreement's not in writing, even if the subcontractor has insurance, that insurance is not going to step in and defend you, and you're going to have to rely on your own policy. So in the subcontractor agreement, you should have a provision that provides that the subcontractor has to maintain an adequate amount of insurance, and that amount of insurance is really up for debate between you and the subcontractor. You want to make sure that the subcontractor identifies you and your company as an additional insured under that policy. And then you also want to make sure that you have the written defense and indemnity agreement in your subcontractor agreement. That way, if you're sued and it relates to the subcontractor's services, you can then make a demand on the subcontractor to defend and indemnify you, and they in turn submit that claim to their carrier, and their carrier then pays for your attorney to represent you and pays with regard to any settlement or judgment that's entered in regard to those services. If there's a claim related solely to your services, your policy would still respond. But this way, again, if there's a claim related to the sub, you don't want that on your insurance policy. You don't want that anchor dragging along and making you have to pay additional premiums or make you a greater risk in terms of an insurer wanting to insure you in the first place. The insurance requirement is really up for debate, but you should always request that that service provider have at least general liability. You should also make sure that if they're providing a particular trade or profession, that they have errors and omissions coverage. A general liability policy is not going to cover somebody doing shoddy work. There needs to be an E&O policy in place to cover their professional services or lack thereof. And you also should have a non-compete and non-solicitation clause in your subcontractor agreement. If you're using the same sub over and over again, you don't want them then going to your referral sources and soliciting work around you. You want to always make sure that you control that relationship. You want to make sure that that subcontractor doesn't go to any of your referral sources and say things that might be negative about you or suggest that they use a different professional other than you. And so non-compete and non-solicitation clauses will provide that that service provider can't compete with you in your field or the field that's identified in your agreement with them, and that they can't then go solicit your referral sources, your clients, or your employees to come and work for them or to send them work. Provided those clauses are in your subcontractor agreement, it prevents that subcontractor essentially from stealing work or doing work around you for which you would normally be compensated. It has to be in writing, and any non-compete or non-solicitation clause must have at least a term that's reasonable and a geographic location with regard to non-competition. Generally speaking, a geographic area where you perform services within a single state can be used in terms of the area where that person cannot compete against you. In terms of the non-solicitation or non-complete, there needs to be an endpoint. So for example, if you and the subcontractor part ways, you might want a year or 2 years in that agreement where that subcontractor then can't go solicit your referral sources or other people that they've met in the course of doing work with you. Now that we've talked about some of the specific clauses, I'm going to talk a little bit about some of the general things that should be covered in your service agreement. You need to make sure you have written permission to access the property. This is particularly important if you're not dealing directly with the homeowner. But we want to make it clear that you are legally allowed to be on that property when you need to be on there, and that your client understands that you're going to be on the property from time to time in order to perform your services. So we want to make sure that that permission is granted, and the best place to do it is in the written agreement with your client. That's also important in terms of advising your client as to what people might be on the property. You want to make sure you have permission to allow the third-party service providers you're bringing into the transaction. You need to make sure you have permission to bring any kind of helpers. If you have outside delivery people, all of that stuff should be addressed in the service agreement. So if you normally operate your business a certain way, or you know every time you do a job you're going to use X company to bring the materials and you're going to use certain specific third-party service providers, you might even mention them in the agreement. But again, if you're doing things the same way over and over again, it can really say that they grant you and anybody else you bring as part of your services permission of the property and permission to enter the property and come and go as need be. The scope of services clause is really where you're telling the client what you do. Now, a lot of people really don't know what a home stager does or what your scope of work is, and so this is your opportunity to explain to your client exactly what you do. Now, it might not just be bringing things, it might be doing the layout, it might be doing the design, but any of those types of services you want to mention as your scope of work in the agreement somewhere, and make sure it's clear and concise. You're not working in a profession where there's regulations that you have to cite to or statutory definitions or other things. So you want to make sure you use the opportunity in your agreement to explain exactly what you're going to do and define those services. You want to make sure you identify the areas of the property that are going to be staged. It's important for a couple of reasons. It's important because it's good for your client to know what areas of the home you're going to be working in and what areas you might not be working in. That way they can schedule other people that might need to be there, painters or people doing contracting work or improvements, and they can make sure that they're not stepping on you in terms of your ability to work in a particular area of the house. It's also important because then your client has a reasonable expectation of what rooms are going to be staged and what rooms won't be staged. And so we want to make sure that they know exactly where it is you're going to be doing your work and what rooms are going to be staged and what rooms will not be staged. Again, if you have clients who are living at the house while it's staged and being shown for sale, you might have materials in particular rooms that you don't want them to use. And so we want to make sure that we tell them exactly what rooms we're going to need to work in to make sure that they can do the preparation and so it's ready for us when we start our work. A staging inventory list is important. You want to make sure the client knows exactly what's going to be brought to the property, and more importantly, this is to protect you in your inventory so there's no discrepancies as to what was yours and what was not yours when it's time to end your services. So we want to make sure you have some kind of a list. Some people prefer to use a separate lease agreement for the staged items. Some people like to include that in the overall services agreement. Either way is fine. Obviously, it's more convenient and practical to include everything into a single agreement, but if you like the way you're doing your business and you prefer to use separate agreements for the staged materials, that's perfectly acceptable. If you're going to incorporate everything into the single agreement, then you want to make sure that you have the staging inventory list there, that it's been reviewed by your client so they know exactly what's going to be brought to the property. I'm going to talk in a couple minutes here about who's responsible for those things, and you'll see why this is critically important, that they know exactly what's being brought to the property. You want to make sure that any provision related to your service fees and any cancellation charges are specifically stated in the agreement. Your service fees can be, as I said earlier, based on a day rate, it can be based on an hourly rate, it can be based on a monthly rate, but it needs to be set forth in the agreement and it needs to be clear to the client what they're going to be paying for the services described in that agreement. If there's a cancellation policy, that needs to be in writing and needs to be in place, and your client needs to be aware of it before you start your work. That way, if there is a cancellation, they can't come back and say they didn't understand that they were going to be charged if they canceled your services for any reason. They might have a particular problem with the property, like a flood or a loss of power. Any of those things might cause a cancellation. As long as you make it clear in the agreement as to what the cancellation terms are and whether or not there will be additional fees, you can enforce it later on if you have to. But if it's not stated specifically in the agreement, particularly when we're talking about price, it's unlikely that a judge would enforce it. So you want to make sure that you have a set cancellation fee to make it much easier. Now, you can certainly do that as a percentage of the overall service fee you were going to charge. You can use a flat fee, but you want to make sure that that fee encompasses the cost to you to cancel and reschedule. That might mean you might have a third-party service provider that's still going to have to be paid by you. And so you should account for all of those things, and if you're creating a flat cancellation fee, make sure that you've accounted for all those particular costs that are going to arise and that you're going to incur as a result of the cancellation of the services by your client. You may also want to include a cancellation provision related to you. If something happens to your health, if something happens that causes you not to have the items that you were going to stage, like a fire loss at a storage facility, or your things get damaged because of a flood or a leak at a storage facility. Any of those things might cause you to need to cancel the services. If that's the case, you need to make sure that you have your cancellation policy in place as well. Now, for example, some people have a cancellation policy that's based on the condition of the property when they arrive to start their services. If there's a contractor working in the room that's to be staged, or a painter, or something else is going on that makes it impractical for you to perform your work, in that situation you want to also have that addressed in your cancellation fee provision, that you can opt out if the property isn't ready to be staged, or you have some concerns about working at the property because other work is going on there. Any additional fees above and beyond your service charges or even the cancellation fee also need to be set out. There's many types of additional fees that might get charged in any transaction, but some of the more common ones that we run into and that we should mention in the agreement are a rescheduling fee. If somebody's not canceling the services but they need to bring you at a later date, there can be a fee attached to that to provide for any additional costs you may have. But again, it needs to be set forth in the agreement. A judge is not going to enforce random fees and charges or interest charges that aren't set forth in writing in the agreement. So you might have a rescheduling fee. You might have a situation where your client doesn't pay on time for whatever reason, and I've heard from stagers who have that problem. Sometimes with realtors, sometimes particularly in the age of COVID, when properties weren't being staged for a period of time, and then the state opens back up and they're allowed to start showing the property again. Any of those extra charges that might be involved in those events have to be set forth in the agreement. And if your client doesn't pay on time, any overdue payment charges, late charges, or collection charges must be included in the agreement. Now, collection charges are a separate animal and a separate source of issues, because as a business, if you're trying to collect from an individual, you're subject to statutory and regulatory requirements as to what you can say in a collection letter, what you're allowed to do or not do, and how you have to communicate that to the debtor. And so with regard to anything related to overdue payments, interest charges, bad check fees, all that stuff needs to be set forth in that agreement so that you can refer to it when you have to send that collection letter to the client, because you are going to have to, in order to substantiate that debt, show that there was an agreement in writing that in addition to the service charges, they agreed to an interest fee for overdue or late payments, or a flat fee for late payments, or return checks, or any of those things that might happen from a financial standpoint with regard to your services. As long as all that stuff is specifically in the agreement and it's not one-sided or unconscionable, you certainly couldn't put a $10,000 charge for a late check. Any of those things that might be considered too onerous on the consumer would likely be stricken from the agreement, and in some cases it may result in you not being able to collect any additional fees, even where somebody holds on to your stuff for an extended period of time beyond the time you agreed to offer it to them for staging. You also want to make sure that if there's any additional day rates you might have, if the term goes beyond the initial 30 or 60 days due to an act of God, due to a sale falling apart, and the property needs to remain staged for an additional period of time, any of those additional charges should be set forth clearly in the agreement and signed off on by the client before you start the work. With regard to some of the general exclusions, we talked a little bit about the layout of the property and work that might be being performed there that might inhibit your ability to do your work. Well, in your service agreement, you also want to talk about some of the things you're definitely not going to be responsible for. First and foremost, you're not there as a home inspector. You're not there to determine whether the property is safe for access by the public or anybody else. Your job is not to identify defects in the property. You're not there to look for defects involving paint. You're not there for defects involving flooring. You're not looking for sloped floors. You're not checking the structure of the house. It needs to be clear to your client that even though you're a professional, your job is not to evaluate the condition of the property in terms of safety. Your job is to stage the property based on an agreement with your client as to how that should look. And so we want to make sure that you're excluding anything that might relate to you being responsible for the condition of the property or the safety of persons on the property for any purpose. You want to make sure that there's exclusions related to appraisal. You're not there to help them determine the value. You're not there to guarantee that the property will sell for a particular price based on your services. So we want to make sure that's clear to the client. And you'd be surprised how many clients need to have that in writing so they understand it, but it's true. And so we want to make sure that anything related to exclusions are specifically identified in our agreement so there's a clear understanding by the client that we are not going to do certain things related to the staging of the property. Photographs and other depiction of the subject property are an important topic with regard to your service agreement. We need to get an agreement from the property owner for you to photograph the interior of the property. Now certainly they could photograph it, and so we want to make sure that that agreement is mutual. That if you're staging the property, that the agent or the other person assisting the seller with the transaction has the ability to take photographs of your staged materials and use them in the MLS listing or Zillow or Redfin or wherever they might be posting the information about the sale. They want to make sure that they can, use your good work in staging the property to advertise it for sale. And so you want to give them permission to use photographs of your items and photographs of the way you staged the property. But you want to make sure that's solely limited to their efforts to sell this particular property. And so they're not just reusing your photos for their own purposes for other advertisements related to how they do their work. But that photography agreement needs to be reciprocal. You also need to have an agreement from them that you can use these photographs for purposes other than the sale of this property. You want to be able to use photographs of your great work to show other clients how skilled you are and what you can bring to the table and how you can enhance their ability to sell this property for a price that they believe is reasonable. And so we want to make sure that you're able to use photographs of your good work or videos of your good work in other advertisements that you may use. And so you want to make sure that you have that written agreement from the property owner that you're allowed to do that. And you also need to set the parameters for yourself that when you're taking photographs or using depictions of work that you've done at someone else's property, that you're not accidentally copying any personal information, photographs of the people who own the property, any of those things that might identify an owner or where the property is should be excluded from the photographs that you might use later on in your advertising or marketing, because we don't want to disclose anybody's private information. We don't want to give anybody any information about who owned the property or how much it might have sold for. And so any photographs that might depict anything other than how your work is staged and the things you brought to the property, those things you shouldn't be photographing or videotaping and using in your later advertisements. But you do need to have a release to be able to show pictures of that house and other people's property in your advertising efforts later on. We also want to make sure that the agreement addresses liability for the third-party service providers, as we discussed a little bit earlier. So we want to make sure the agreement in your service agreement as to third-party service providers is simply that you're not responsible for any of their work, you're not responsible for their safety on the job, and you're not responsible for directing them on how to do their work. That any third-party service providers brought to the transaction aren't under your exclusive control, and that you're not going to bear liability for anything that might happen as a result of their work. Now certainly, again, you want to make sure you have a subcontractor agreement for any third-party service providers that you use on any kind of a regular basis. That lays out, again, this idea that you're not going to be responsible. But in situations where it's a one-off, or you may not have a service or a subcontractor agreement for whatever reason, you also want to make sure your client understands that you're not responsible for any of those people or what they do or don't do relative to the property. And so the best place to do that, again, is in your service agreement with your client. The indemnity and hold harmless agreement in your service agreement we discussed earlier should relate to, in this situation, your client. And so we want to make sure, in addition to these subcontractors with whom you should have an agreement as to indemnity and defense, you also have an indemnity and hold harmless agreement with the owner of the property or the person commissioning your work. And here we're looking, instead of looking at the services of a third-party provider, we're looking more about safety and the care and custody and control of the items you're going to leave at the property for purposes of staging. This is an agreement with the property owner that they're going to indemnify you and hold you harmless as to any claim made by a third person, for example. Let's say somebody comes to the property for an open house and they trip on a rug, and it's a rug that you staged, and they want to claim somehow that you might be responsible because you placed or selected the rug. Well, we want to make sure there's a provision in your agreement that says that the property owner is going to defend and indemnify you against any personal or bodily injuries incurred by somebody as a result of the property being shown to the public. Because ultimately, the owner of that property has control over the area when people visit, and has the ultimate legal responsibility because they're opening up the property to the public for a commercial transaction. So they're also in the best place to take precautions, to notice that there might be a slip or tripping hazard, to notice that the rug isn't attached to the floor and might come up if somebody walks across it, to know that there's a sharp corner on a piece of furniture that's been placed in an area where somebody might walk. All of those things the property owner is better suited to address. And so we want to make sure that there's a solid indemnity and hold harmless agreement between you and your client, that they're going to indemnify you and hold you harmless against claims by people who might be on the property for that commercial purpose. This part of the agreement can also address the care, custody, and control of your things that you're going to leave at the property. And you want to make sure that your client is going to indemnify you and hold you harmless as to any damages related to that property. You should also address in your service agreement the use or the prohibition against the use of items that are rented from you by the client or part of the staging process. We certainly don't want anybody using the furniture as their own. We don't want it stained. We don't want people eating on the couch. We don't want people eating at the table that you just placed and scratching it up. These are your things, but we need to make sure that agreement is clear between you and your client. And again, the only place we can do that is the service agreement. And so we want to make sure that there's a prohibition in there from the client using any of your things in their daily life, and that those things are only used as part of the staging and showing of the house. If you're going to have TVs in the property, you want to make sure somebody isn't using it. We want to make sure that, for example, the owner knows whether or not there's bed bugs at the property. We want to make sure that the owner understands that none of the things should be moved by them without your permission, because it can cause damage. We want to make sure that the owner is not removing any of your items from the property without your permission and storing them somewhere else where they might get damaged. We want to make sure all those things are addressed in terms of the use of the items that you're going to stage at the property, so there's no misunderstanding whatsoever between you and your client as to the fact that they should not be using it for their personal use, and it's only there for the purpose of staging or showing the property. Your service agreement should also include a disclaimer of any warranties or guarantees. In particular, we're not guaranteeing that the property will sell based on your staging efforts or based on the property that you place at the house. There are way too many factors that go into whether or not a property sells above and beyond what you do for you to then take responsibility in any way for the inability of the people selling the property to sell it. And so we want to make sure that you're not warranting that your services will guarantee a sale, that your services will guarantee a sale at a particular price point, or that it will attract a specific type of buyer or a buyer with specific income or specific other qualifications. You're not there to do any of that. You're there just to stage the property and use your professional skill to bear on use your professional skill to assist in the selling of the property. You can't guarantee that it will sell, and you also can't warrant that your goods and the things you're going to place there are warranted for a specific purpose. They're just there to be staged, but you can't guarantee anything related to them other than that they will be placed there and that they will be in good condition. The notice of claims provision we spoke about earlier, but we want to make sure that when we talk about that it's a claim, any claim related to your professional services or the staged items is subject to that time limit before somebody has to bring a claim. The other claim notice thing that we like to include in these is the ability for you to see the conditions that are being complained of. So let's say there's a claim against you related to physical damage to a property as a result of the staging. A wall was damaged, or a floor was damaged, or something was spilled and caused a stain and water damage. In those situations, we want to make sure that the client notifies us quickly so that we can come assess the situation, photograph it if necessary, and also to make sure that our things aren't damaged as a result of what happened. And so in addition to the time period within which they can bring a claim against you, we want to have a notice provision that requires that they notify you within a short period of time about the condition and give you an opportunity to correct it and or photograph it and document it. Generally, I use 10 days. Within 10 days of the client realizing that there's an issue, they have to notify you and give you the opportunity to either cure the defect or to protect your property or to photograph the conditions they believe that you caused. And so we want to make sure that your contract has that provision in there so that they're required to notify you. Now, under the law, there's always an exception, and certainly if it's an emergent thing, like a flood, for example, and they have to move your property and get it out of there quickly, a court isn't going to hold them to that 10-day period to give you a window to come look at what's going on. And quite honestly, it's probably in your best interest that they don't. But in those situations, a court can always override and input some reasonableness factor into the agreement and how it's enforced. And this is one of the ways that can happen. But you should have a provision in there that requires that your client get a hold of you in a reasonable amount of time, notify you of the claim, and give you the opportunity to address it. It's important in your contract also to have a choice of law provision, that it's clear that a particular state's law is going to apply to your work, and that should be the state where you're performing the services. So if you're performing services in multiple states, then you want to make sure that you're using an agreement that identifies the particular state law that's going to apply to that particular service. So if you're doing work in Missouri, you're going to want to make sure you cite Missouri law as the source of law for your contract. That's important because when we do contracts for our insureds, we try to make sure that the provisions in it match up with what you're allowed to do in that particular state. And so it's important that you cite that state law will apply to the claim. We want to make sure that the law applied to your case is the law of the state within which you perform your services. Now, the last thing I want to talk about before we move on to the Q&A session relates to the COVID-19 situation and particularly addendums that you might want to use to your staging services agreement. Certainly this has created a whole host of legal issues, certainly a whole host of logistical issues related to trying to perform services. If you were in a state where real estate transactions couldn't move forward, or you couldn't get your staged items out of a particular property for a period of time, you understand exactly what I'm talking about. But when things like this come up, like COVID-19, where there's particularly a health concern, we always want to make sure that we examine what we do in our business and how our risk may be increased because of the addition of this situation. So COVID-19 presented a situation where we had to come up with a way to protect you against claims related to transmission of COVID, and also to protect you from getting COVID. And obviously that's the much more important part of this. You know, lawsuits and claims, there's insurance, there's ways to deal with those, but your health is something that can't be replaced. And so we want to make sure that there's some guarantees in place for you that you're not coming into a situation where you might be exposed to this and be injured and suffer a disease that may kill you. So we want to make sure that it's clear, and we want to make sure that it's stark and it advises people exactly what it is that's at issue here. So you would want to say in there, for example, that the parties are aware that COVID-19 exists and that it's a serious threat to health and well-being of any person, regardless of their age. We want to make sure that they fully understand the transmission of COVID can be made through contact with people or through surfaces or items exposed to COVID. And we want to make sure that there's an agreement between you and the other parties involved in the transaction, and not just the owner, but maybe the agent in this situation as well, or anybody that's going to be regularly at the property or might be in your presence when you're performing your services. We want to make sure that they certify that they have not, or anybody residing with them has not, tested positive for COVID-19 or is awaiting the test results from a test for COVID-19 because they felt it was important they get one. So if they think they were exposed and they're waiting on those results, we want to make sure that you're not in contact with them and that they're not in contact with your things. We want to make sure that they or anybody else in their house has not been placed under quarantine as a result of COVID-19. Now, for example, we have a lot of situations where people traveling from different states now, when they come to the state that they're arriving in, have to quarantine for 2 weeks. And so those are the kinds of things we want to know about. Are you going to be in the presence of, or are your things going to be in the presence of anybody who has been quarantined for a period of time because they may have been exposed? We want to make sure that neither the people you're going to be in contact with or anybody they live with have traveled to any place, whether outside of the United States or otherwise designated as having an ongoing outbreak of COVID-19. We want to make sure that neither your client or anybody else you're going to deal with or anybody they might reside with has had contact with somebody who has tested positive. And we want to make sure that they haven't had contact with anybody who has a fever or any kind of symptomology related to the COVID. And we want to make sure when people sign off on that agreement, also, particularly your client and the agent, that they sign off that they believe that no third parties have visited the property or will have access to the property who may have been exposed to COVID or are currently asymptomatic related to COVID or waiting for test results. And we want to make sure that they fully understand that COVID can be transmitted by contact with people, surfaces, and items. It could result in bodily injury or illness. And the parties understand that we cannot, you in this particular situation, you're giving the contract an addendum to your client. We want to make sure that they understand that you cannot in any way ensure, warrant, or guarantee the safety of any person from exposure to COVID-19. Having full knowledge of the potential risks, we want to make sure that they sign off on it, that they fully understand the risk, that they understand they're waiving any rights or liabilities to bring a claim against you related to COVID or transmission of COVID. And that they sign off on that with full understanding and intent to still use your services. Again, this is a two-way street. It's to protect you and your people, and also to protect them and let them understand that you're in no way responsible for that. Now, in reality, it would be difficult, if not impossible, to prove how somebody contacted or transacted COVID in a particular situation. If they go any more than 2 or 3 places in a single day, they could have definitely come into contact with it or been infected. And so we understand that it would be very difficult for somebody to bring that claim. But this is crucial because it's protecting you and your well-being, and at least giving you some semblance of control as to who you're exposed to and whether you're exposed to any kind of conditions that could cause you illness. Again, it's not so much the legal issue as much as giving you some reassurance that you're not putting you and your employees at risk by performing your services in the age of COVID-19. And this would be true for any kind of an outbreak of a virus or bacteria. You could use an addendum similar to this to address conditions that might be at the property, like mold, or that people are going to represent to you that there's no condition of the property that you might be exposed to, that you might be susceptible to. For example, mold is a great example, or they're going to warrant to you that there hasn't been an asbestos outbreak after they've removed some asbestos. These are the type of things you might address in an addendum to your service agreement as it comes up. But for now, you should certainly use a COVID-19 addendum, and if you're part of the RESASURE program, we have those available to you for your use. But if you're doing one on your own, you should consider the things I just mentioned as things you might want to include in that agreement.